Namaste everyone, I'm Tanya Pandey and I welcome you to today's episode of Courts This Week on Live Law. To find out about the latest legal developments happening in the country, subscribe to Live Law and click the bell icon to not miss any videos from us. We'll begin the episode with judgments from the Supreme Court and then cover the High Courts and other courts. The Supreme Court has dismissed the plea seeking a special stray round of counselling for NEET PG 2021 to allow the candidates to participate for vacant seats available after the conduct of a stray vacant round of All India quota. A bench of Justices M.R. Shah and Anirudh Bose was hearing a petition filed by the doctors who appeared in NEET PG 2021 and participated in rounds 1 and 2 of the All India quota and state quota counselling, which were followed by All India mop-up and state mop-up rounds. The top court came down heavily upon the Medical Counselling Committee, stating that leaving seats in NEET PG vacant not only puts aspirants into difficulty, but also leads to dearth of qualified doctors. Approximately 1,456 seats have remained vacant since May. The Supreme Court on 7th June granted the state of Telangana 2 weeks to deposit the cost of Rs 2,50,000, which the court had imposed on the state while declaring the government orders issued by the erstwhile state of Andhra Pradesh of providing 100% reservation to scheduled tribe candidates for the post of teachers in schools in the scheduled areas as unconstitutional. The vacation bench of Justices M.R. Shah and Anirudh Bose directed the registry to transfer the amount to the Mediation and Conciliation Project Committee once the same has been deposited. Reiterating that the court interferes in criminal proceedings under Section 482 of CRPC in rare and exceptional cases, the Supreme Court has stressed that criminal proceedings can be said to be an abuse of the process of court when the allegations in the FIR do not at all disclose any offence or there are materials on record from which the court can reasonably arrive at a finding that the proceedings are an abuse of the process of the court. The bench of Justices Indira Banerjee and A.S. Bopanna was hearing an appeal against a decision of the Allahabad High Court, allowing the criminal miscellaneous writ petition before it and quashing the FIR. The Supreme Court on 10th June dismissed pleas seeking an extension of time schedule and conducting an additional mop-up round to fill up seats which have remained vacant in nursing courses for the academic year 2021-22. A vacation bench of Justices M.R. Shah and Anirudh Bose, while dismissing the pleas, observed that the time schedule for admission in an educational institution has to be adhered to. The bench said that the process of admission to an educational institution cannot be endless and must come to an end at a particular time, and any extension or deviation from the time schedule may affect education. The Supreme Court has observed that the public trust doctrine is part of the law of land. The state also has to act as a trustee for the benefit of the general public in relation to the natural resources so that sustainable development can be achieved in the long term, the court observed. The public trust doctrine primarily rests on the principle that certain resources like air, sea, waters, and the forests have such great importance to people as a whole that it would be wholly unjustified to make them a subject of private ownership. Let us now go over judgments from the High Courts and other courts. The Allahabad High Court has quashed criminal proceedings against an accused, Bhavesh Jain, in the 2016 Uttar Pradesh Jal Nigam recruitment scam case. The bench of Justice Vikas Kumar Srivastava noted that the complaint and the charge sheet submitted against the accused, a software engineer, did not disclose the commission of any cognizable offence under the relevant sections of the Indian Penal Code and set aside the impugned summoning order passed by the Special Court Anti-Corruption CBI Central Lucknow to the extent of the applicant Bhavesh Jain. The Telangana High Court has sentenced an IPS officer and 3 police officers to 4 weeks of imprisonment in a contempt case. Justice G. Radharani observed that the contemners had violated the direction of the court for issuing notice of appearance in terms of Section 41 capital A CRPC to the accused within 2 weeks from the date of institution of the case, as per the directions of the Apex Court in the 2014 Arnesh Kumar vs State of Bihar case. The Karnataka High Court has held that on the child attaining 18 years of age, the rigor under Section 33(5) of the Protection of Children from Sexual Offences Act 2012 gets diluted and sequentially will not become a bar for seeking recalling and further cross-examination of the victim under Section 311 of the CRPC on an application made by the accused. A single-judge bench of Justice M. Nagaprasanna made the observation while allowing the petition filed by a 23-year-old challenging an order of the trial court which had rejected his application to recall the victim for further cross-examination in a case registered against him under Sections 376 and 506 of the Indian Penal Code and Sections 4 and 6 of the POCSO Act. The Karnataka High Court has reiterated that the landlord-tenant disputes governed by the Transfer of Property Act 1882 are arbitrable in nature. The single bench of Justice E.S. Indaresh observed that the Supreme Court, in the 2020 case of Vidya Dolia vs Durga Trading Corporation, had overruled its decision in the 2017 Himangi Enterprises vs Amarjeet Singh Ahluwalia case. The court held that the landlord-tenant disputes between the parties under the lease deed, which was governed by the Transfer of Property Act, could be referred to arbitration. The Ahmedabad bench of the Customs, Excise and Service Tax Appellate Tribunal, CESTAT, consisting of Ramesh Nair, judicial member, and Raju, technical member, has ruled that IT services provided by the assessee to the associate company in the USA amount to an export of services. The adjudicating authority demanded the service tax, holding that the appellant's supply of services to the corporation Messrs. Celtic Cross Holding Incorporated, USA, did not constitute export. The adjudicating authority observed that the appellant could not prove that they had received the export proceeds in convertible foreign exchange. The National Company Law Appellate Tribunal, Principal Bench, comprising of Justice Ashok Bhushan, Ms. Shrisha Marla and Mr. Naresh Salecha, recently allowed the appeal filed by the suspended director of HCL Technologies and set aside the Corporate Insolvency Resolution Process, CIRP, initiated against HCL. NCLT Bench 2 New Delhi on 17 January had admitted the insolvency petition filed by an operational creditor under Section 9 of the Insolvency and Bankruptcy Code 2016 against HCL for a debt of Rs 3.54 crores. Earlier, NCLAT on 19 January, while issuing notice in the appeal filed by suspended director of HCL, stayed admission order of NCLT New Delhi. That's all for today. Thank you for joining us. I'm Tanya Pandey for Live Law and you're watching Courts This Week. Have a great week ahead.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.